All right, so today, let's really dive deep into some fascinating territory. The world of Canadian inadmissibility. We've got a whole stack of sources here, legal documents, case studies, real-world examples, and we're going to explore all the reasons someone might be barred from entering or staying in Canada.
Yeah, it's really interesting stuff.
Imagine you're all set for that trip to Canada,
Yeah.
right? Maybe a ski trip to Whistler, or even you're thinking about moving there permanently, but
You hit a snag.
yeah, exactly. There are certain things that can put a hard stop to those plans, and that's what we're diving into today. We're
Exactly.
talking about things like security threats, involvement in human rights violations, past criminal convictions, health concerns,
Financial stability, even misrepresenting information on your application.
and even having a family member who's inadmissible can affect your chances.
That's right. It's pretty wild.
Yeah, it really is. It's like a complex web of factors that all kind of intertwine. I was particularly struck by this idea of reasonable grounds to believe that came up a lot in these sources.
Yeah, that's a key concept.
It's the standard of proof for inadmissibility in a lot of cases.
hmm
And what I found fascinating here is that it's a lower standard than like beyond a reasonable doubt, which is what we're used to hearing about, in criminal court.
Yes, that's a really key distinction. Yeah.
So help us understand that a bit more.
Immigration officials, they don't have to be absolutely certain that you pose a risk, just that there's, enough evidence to make it a serious possibility. And I think one of the best ways to illustrate this is this case that was highlighted in our sources involving a man who worked as a bus driver in Srebrenica during the Bosnian War.
Srebrenica, wow. That's a really tragic chapter in history.
Yeah.
But a bus driver, what does that have to do with inadmissibility?
Well, even though this man wasn't like directly involved in the violence that happened there, his job, placed him in close proximity to those who were. And the court ruled that his presence and potential knowledge of the events, it met that reasonable ground standard for complicity in crimes against humanity.
Oh, wow. So even seemingly ordinary jobs can get tangled up in these situations.
Yeah.
That's a really, really sobering thought. And speaking of serious situations, our sources mention that Canada has this list of designated regimes, right? The government's considered to have engaged in some pretty heavy human rights violations.
That's correct. Saddam Hussein's Iraq, the Taliban in Afghanistan, the Bosnian Serb regime, just to name a few. And being associated with these regimes, even without direct involvement in violence, can lead to inadmissibility.
Okay, so how does Canada define, like, association in this context? Would simply living in one of those countries during that time period be enough?
Well, no, it's not quite that simple. Canada looks at whether someone held a position of influence within those regimes, what they call a prescribed senior official.
Okay.
This could include heads of state, military leaders, judges, even senior advisors. It's about their potential to have been complicit in or even directed human rights violations.
So it's really about that level of authority and influence, not just being a citizen during a turbulent time. Okay. Now, what really caught my eye in these sources were the case studies on criminal inadmissibility. They really kind of bring this whole issue to life. One example involved Maria, this artist living in France, who got convicted of vandalism
Vandalism.
for, get this, kissing a $2 million painting with lipstick.
Ah, Maria. A passionate art enthusiast, perhaps.
Maybe a little too passionate. But how would Canadian immigration law view a case like hers? Would a lipstick smooch on a canvas really keep her out of Canada?
Well, to answer that, we kind of have to understand the difference between what Canada considers indictable and summary offenses.
Right.
Indictable offenses are, more serious crimes, while summary offenses are less so. Maria's vandalism charge would likely be considered a summary offense. It wouldn't automatically make her inadmissible, especially if it was an isolated incident and she had a clean record otherwise.
So a single summary offense doesn't necessarily mean you're banned for life. That's somewhat reassuring, I suppose. But what about something a bit more serious, like resisting arrest? There was another case study. It involved Tom, this American hockey player, who got into a bar fight and then resisted arrest, admitting to willfully obstructing a peace officer.
Interesting.
So how would that be viewed?
Well, Tom's situation brings up some interesting points. Resisting arrest is generally considered an indictable offense in Canada. However, immigration officials would look at the specifics of his case. Was there violence involved? Were there injuries? What was the sentence imposed? These details matter.
So even within a category like indictable offenses, there's still a lot of nuance in how these cases are assessed. It's not as simple as, checking a box, is it?
Not at all. Each case is evaluated on its own merits.
All right, let's keep rolling with these case studies. How about a DUI? Nikki Pop-Tart, an American singer, got a DUI and was sentenced to 4 days in jail. Would that be a deal breaker for entering Canada?
DUIs are certainly taken seriously. However, for Canadian immigration purposes, unless there were aggravating factors like injuries or a really high blood alcohol level, it would likely be considered a summary offense.
Okay, similar to Maria's case.
Yeah.
So again, not an automatic disqualification, but definitely a red flag that would be scrutinized closely.
Yeah.
And finally, we have Nico Popcart, another American singer, no relation to Nikki, who got 4 days for public nudity. What kind of ripple effect would that create for entering Canada?
Well, public nudity can be either a summary or indictable offense, depending on the circumstances. Canadian officials would need to delve into the specifics of the case to determine, the severity and potential impact on admissibility.
So streaking down the street after losing a bet might be viewed differently than, say, a more deliberate act of indecent exposure.
Yeah.
It's all about context.
Right.
But here's something that really surprised me. Some crimes committed outside of Canada might not even be considered offenses here. That seems like it could create some interesting legal dilemmas.
It does, and our sources refer to this as a bilateral irritant.
Yeah.
Essentially, it's a point of friction between the two countries involved because Canada might not want to penalize someone for something that's perfectly legal within its own borders.
So imagine being convicted of something in, say, country X that's not even a crime in Canada. Talk about a culture clash. And speaking of clashes, what happens when personal circumstances bump up against these inadmissibility rules? We still haven't touched on those catch-all categories like health concerns, financial stability, and even having an inadmissible family member. Those seem like areas where things could get really complicated. Let's unpack those next.
Okay, so we've been exploring the ins and outs of inadmissibility to Canada, and it's clear that this isn't just about, major crimes or international incidents. Our sources also dive into these catch-all categories that can trip people up, things like health concerns, financial stability, even having an inadmissible family member.
Right. These might seem less dramatic than, say, being flagged as a potential security threat, but they can be just as impactful when it comes to, trying to get into Canada.
Absolutely, yeah. And one of the most common misconceptions is that health inadmissibility only applies to contagious diseases.
Yeah, I think most people would assume it's about, protecting public health from something like a highly contagious virus or something.
Right, of course, that's part of it. But Canada also considers whether a health condition could place what they call an excessive demand on the healthcare system.
Excessive demand. So it's not just about whether you as an individual are healthy, but also about the potential strain on Canadian resources.
Exactly. And there's actually a case highlighted in our sources involving someone with a chronic illness
Okay.
that required ongoing specialized treatment, and the Canadian government determined that the cost of this treatment would place an undue burden on the public healthcare system, and the person was deemed inadmissible.
Wow. That's a really tough situation. It raises all sorts of ethical questions about pre-existing conditions and access to healthcare. But I guess the underlying principle is about ensuring that newcomers can be self-sufficient and not overly reliant on social services.
Right, and that's a key factor in financial inadmissibility as well.
Right. So you need to be able to support yourself financially in Canada. But how does Canada actually assess that? Do they have a specific income threshold or something?
It's not that straightforward. There's no set income requirement, but they do look at your overall financial situation.
Yeah.
Stable income, savings, assets to figure out if you're likely to need social assistance.
So the holistic view.
Yeah, they want to see a realistic plan for supporting yourself and any dependents you might have. And our sources actually mention a case where someone submitted altered bank statements
Oh, yikes.
to inflate their financial status, which ultimately led to their inadmissibility.
So not only do you need to have your finances in order, but you also need to be completely transparent about them. No fudging the numbers. And that kind of brings us to misrepresentation, which seems like a pretty broad category.
Yeah, it is.
What kind of things would fall under that?
Well, misrepresentation is basically providing false or misleading information on your application. It could be anything from omitting periods of residence in certain countries to failing to disclose a past criminal conviction. Even seemingly small omissions can have serious consequences.
It's like, I imagine that trying to hide something from immigration officials would be like trying to hide an elephant in a broom closet.
Yeah.
It's eventually going to come out, and the consequences are going to be far worse than if you'd just been upfront from the beginning.
Exactly. Honesty and transparency are crucial throughout the entire immigration process. And then there's the issue of inadmissible family members.
Right.
This is where things can get particularly complicated.
Right, because it's not just about your own individual circumstances. It's about your family ties as well. How far does that extend? Like, if my great aunt is inadmissible, would that affect my chances of entering Canada?
Well, no, it's not about distant relatives. Canadian immigration law focuses on close family members, spouses, common law partners, dependent children. These relationships are considered particularly significant when assessing admissibility. Our sources actually point to a case where someone's spouse had a criminal record that made them inadmissible.
Oh, wow.
And even though the applicant themselves had a clean record, their application was rejected because of their spouse's inadmissibility.
So you could be the most upstanding citizen in the world, but your spouse's past could still hold you back. That seems incredibly unfair.
It can be a really difficult situation, but the logic is that family members often share finances, living arrangements, and even, responsibility for each other's actions.
Yeah.
So the inadmissibility of one family member can raise concerns about potential risks or burdens associated with the entire family unit.
So it makes sense from a logistical standpoint, but it still highlights the, complexities and sometimes the seeming unfairness of these immigration rules. And speaking of difficult situations, I know we have to talk about removal orders. It's a topic that probably makes people shudder, but it's important to understand what's at stake here.
You're right, it's not a pleasant topic, but it is a reality for many people facing inadmissibility. Essentially, a removal order is a legal document that requires someone to leave Canada. There are different types: departure orders, exclusion orders, and deportation orders, each with varying levels of severity, kind of like a warning system with escalating consequences.
Okay, so help us break down those different types of removal orders. What are the key distinctions there?
Well, a departure order is the least severe. It basically gives you the opportunity to leave Canada voluntarily
Okay.
without necessarily barring you from returning in the future. Then you have an exclusion order, which is a bit more serious. It bars you from returning to Canada for 1 year after the order is in force.
That's like a timeout.
Yeah, exactly. There's like a timeout period to reflect on the situation and address the reasons for your inadmissibility. And finally, there's the deportation order, which is the most severe form of removal. It means you're inadmissible to Canada indefinitely, and you would need special permission to even attempt to return.
Wow, that's quite a range of consequences. It really underscores the importance of understanding the rules and taking them seriously. But what about those who find themselves facing inadmissibility? Is there any hope for them? Are there ways to appeal or find exceptions to these rules?
There is. While Canadian immigration law is designed to protect Canada's interests, it also aims to be fair and compassionate. There are exceptions built into the system that can provide a path for those facing inadmissibility.
We've been on quite a journey through this world of Canadian inadmissibility, talking about serious offenses, reasonable grounds, and those kind of surprising catch-all categories. We even got into the different levels of removal orders. But before we wrap up, let's shift gears a bit and talk about those glimmers of hope, the exceptions that can give people facing inadmissibility a chance to still find their way to Canada.
Yeah, that's a really important point. Canadian immigration law, it might seem quite strict, but it's not without compassion. There are a number of exceptions that allow for flexibility and taking into account individual circumstances.
So what are some of those lifelines that people can grab onto? I saw in our sources something called a temporary resident permit.
Yeah.
What exactly is that?
A temporary resident permit, or TRP, it's essentially a way to temporarily overcome inadmissibility. It allows someone to enter Canada for a specific period, even if they wouldn't normally be allowed in, and they're often granted for compassionate reasons,
Okay.
like visiting a sick family member or attending a funeral, things like that.
So it's a way to address those urgent or extraordinary situations where the usual rules need to be bent a bit.
Yeah.
Makes sense. What other exceptions are there?
Well, there's also what's called humanitarian and compassionate consideration, or H&C for short.
Okay.
This allows the Minister of Immigration to grant someone permanent residency even if they're technically inadmissible.
So this is where things get a bit more subjective, right? It's
Right.
about appealing to a sense of empathy and recognizing the human impact of these decisions.
Exactly. It's about demonstrating that your circumstances warrant special consideration. Things like your ties to Canada, your family situation, the potential hardship you might face if you had to leave. All those things come into play.
I imagine these cases are often quite emotional and require a lot of careful consideration.
Oh, absolutely.
Are there any other avenues for appeal?
Yes, there are also what are called public policy considerations. These allow the minister to grant exemptions based on broader societal benefits.
So if someone, let's say, has some really unique skills or knowledge that could contribute to Canada in a significant way, that could be a factor.
Exactly. It's recognizing that strictly sticking to the rules might not always serve Canada's best interests.
Right.
Sometimes flexibility is needed to attract talent or address specific needs in the country.
It's about balancing individual circumstances with the overall good of the country.
Right.
Now, there was one more exception in our sources that I found really interesting, the national interest exception. What is that all about?
Yes, the national interest exception. This is a pretty powerful tool. It gives the Minister of Immigration the authority to declare someone admissible, even if they fall under certain inadmissibility grounds.
Wow, that sounds like it's reserved for some pretty extraordinary cases.
You're right. It's used very sparingly, typically when someone's presence in Canada is considered to be of significant importance to the country, maybe for economic, scientific, or cultural reasons.
It's fascinating to me how these exceptions allow for a degree of nuance and flexibility within what can seem like, a very rigid system. But even with these exceptions, I'm struck by the fact that it ultimately comes down to human judgment, right? Someone, somewhere, has to make a decision about who gets in and who doesn't.
That's a key takeaway from all of this, isn't it?
Yeah.
We can talk about all the laws and regulations, but in the end, there's a human element to every immigration case. And that leads us to a question we wanted to leave our listeners with today. If you were the Minister of Immigration with the power to grant entry to Canada, what factors would you consider most important? What would it take for you to say yes to someone, even if they technically fell under one of these inadmissibility grounds?
That's a really thought-provoking question, isn't it? It forces us to grapple with some really complex issues. Issues of fairness, security, compassion, even the definition of what it means to be Canadian. And that, I think, is the beauty of a deep dive like this. We've uncovered a lot of information, but we've also raised more questions that challenge us to think critically and engage with these issues on a deeper level.
And hopefully, this deep dive has equipped our listeners with a better understanding of Canadian inadmissibility, not just the rules, but the stories and complexities behind them.
Exactly. That's what we aim for, to empower you with knowledge and spark those aha moments. So keep exploring, keep questioning, and as always, thanks for joining us on the deep dive.